Good morning. First off, Judge Zone, thank you for your patience in the time issues. We were delayed on the floor longer than we anticipated, for sure. But thank you so much for being here this morning. So welcome to House Human Services. We are taking up our omnibus DCF bill and have asked Judge Zone for his thoughts and any feedback that he might have on this bill. And as you can see, it covers a lot of different things, and you may have feedback about some particular areas and not on other areas. So we welcome any feedback that you have. So thank you for being here, Judge.
It's my pleasure. Tom Zone, Chief Superior Judge. And as the chair has indicated, there's a lot of different sections here, and many of them are obviously policy sections that the court does not weigh in on. I thought I would just touch base on a few areas that I noted that may be of interest to the committee moving forward. In section 4, the section that deals with the unaccompanied homeless youth, on page 8 of the bill, it talks about a consent on line 7, subsection E, and it talks about consent. And even though this isn't tie into the judiciary per se, I did want to note that when I read this statute, the question I had was, well, it says the parent shall consent. Well, what if they don't? Well, then it says, well, it can be implied by certain acts. Well, is it really an implied consent, or is it saying that if you do X, we deem it consent? And it might be a nuance or a distinction without a difference to some, but I just think that the language is important when you're looking at parental rights. And what in the courts, in the criminal docket, for instance, if there's going to be a consent, it has to be a knowing and voluntary consent. And so the question I had was, when it says they shall consent, what does that really mean? Again, what if they don't? And what if a parent is deemed to have given implied consent, but they want to contest it? They say, I don't agree with this. There's no mechanism for that here. Present for the parent to move forward to say that he or she disagrees with this process going on for their child, or having DCF stand in loco parentis, essentially taking their parental rights and making those decisions for them. So I just point that out as something. Certainly I have not watched all the testimony. Maybe the committee has discussed that, but that was something that struck me. On line 12, it says consent can be demonstrated by a letter from a homeless service provider or school district homeless liaison or other appropriate staff member. But it doesn't say what the substance of the letter is. And does the letter say the parent gives consent? Or is the letter intended to say that the homeless service provider or school district homeless liaison gives consent? And if that's the case, involving them, if I'm not mistaken, earlier, I think it's on page 5, the providers and the liaison were actually part of the process for certification. And so it seems that, and maybe it's intentional, but you have a process where providers are going to be certifying someone for something, and then you're then jumping them down. It looks like being able to actually give the very consent that they're certifying them to go and get. So,
thank you.
But this bill does not have in it, section 4 does not have in it any court action. And so it's not something that the courts would necessarily see unless parents are challenging it, it appears, or have concerns about, or anyone's challenging it, or have concerns about the way it's implemented. So the next section I would hit on is on page 24. It's section 13.
Judge, may I just ask you, we've actually touched on that point that you were just making, about it just says, section 4 does not require any court action. That was something that came up in testimony, and, I'm unclear about whether you're recommending that there is something that the court should do or not.
I would not weigh in on whether or not as a policy that there should be court action. I simply want to, I will however, think it's fair to identify that it's not there. And so
Yes.
the question for the committee on a policy is, do you want to provide an identified mechanism for a parent, for instance, whose child is subject to, who's going through this process, to be able to challenge it? And if you do, I would suggest at that point, you would want to spell out what is the due process that you want to afford, because there are constitutional rights for parents. And so due process for a parent to exercise their parental rights is something that has been recognized as, their right as parents. So if you want to provide a clear and identified mechanism that a parent seeking, to challenge a finding or whatever it is, I would suggest that at that point you would want to identify what the process is, because it's not clear whether, for instance, it's a writ of mandamus that someone would have to file an action to say we want the court to mandate something, and that's an extraordinary writ. That's the phrase that's used in the law, or whether it's a Rule 75 appeal from governmental action. So the mechanism for what you do for the next step is not clear.
Okay, thank you. And as you said, it's a policy decision about whether we, at this point in time, we haven't done any markup on the bill yet. But I think that's as you pointed out, a policy decision about whether or not that we are looking to have a venue or opportunity for a parent to challenge that. Thank you for your thoughts on that.
Any other questions on that section?
Doesn't look like it. Thank you.
On section 13, which is on page 24, it starts, I guess, on page 23, section 13, judicial review of aftercare placements. It's unclear whether this is if this is intended to apply only to minors, not to minors. What if a minor, generally if the court's going to vacate an order for a minor, we have provisions for that on how we're looking at things. And so it's unclear what category of youth this is intended to apply to. Is this intended to be more of a voluntary agreement under 33 VSA 4904 and aftercare and address that? Now, I've tried to get additional information, and I understand that there may be some thoughts from DCF or others as to where it goes, but irrespective of what we might think it's intended to apply to, clarity would be helpful to make it to make sure everyone's on the same page. This is what it applies to. This is the group of individuals it applies to. And the last line talks about the court approving an aftercare placement or program if it determines that the placement or program is in the best interest of the child. Again, we have best interest standards for approval. We use them for whether it's termination of parental rights, permanency plans. The question is here, what if the court says it doesn't approve it?
Okay. Yeah, no, I understand what you're saying. Representative Donahue, I think, has a couple of comments / questions.
Yeah, thank you. I think that well, first of all, I agree, you're right. It needs clarity. I think that the deputy commissioner of DCF is the person who will be able to help us clarify it, because it has a very narrow, specific purpose, I think I've been in contact with you a little bit earlier, of meeting federal criteria that allows us to draw down federal funds for these services. And so I can't even off the top of my head tell you what age, we know what it is by looking at the federal statute that says for these services, we will pay if, and so we can draw it from that. And as I said, Deputy Commissioner Radke will be able to help point it to you. And it does need to say that explicitly here.
Yeah, I suspect that Deputy Commissioner Radke has a masterful command of all of the acronyms that you are now referencing. The F's and the Q's and all, and yes, so what my recommendation would be is that what you come out with after visiting with Deputy Commissioner and deciding on is make sure it's very clear who this applies to. And again, if the court gets to a conclusion and says, we don't approve this, well, because right now we don't approve the Section 4904 aftercare. So what's the intent here? And that should be clear. And we understand best interest standards. It's a broad concept. So if you look at, for instance, parental rights and responsibilities under Title 15, it says in determining the best interest of the child, Section 651, it will tell you look at the following factors. Here, there's no factors identified. So if you really wanted to identify when you talk about best interest for this analysis, what specifically are the factors that you'd like the court to look at? When we look at Title 33, section, let me grab it here, 5114. It talks about best interest of the child. And in that circumstance, it's as part of a termination of parental rights. And we look at it has specific factors there. And so while the term best interest gives some level of guidance, it's very broad. And if there is a more focused best interest standard and factors that the committee and the legislature thinks should be reviewed, they should be set out in the statute.
Go ahead, Representative.
So just to follow up, I can't speak for where the committee's policy sense will be, but if we were to say, Section 13 is premature without fine tuning, do you have any thoughts about Section 14, which would say DCF in consultation with the judiciary, come back to us and tell us how to do this so that we meet the federal requirements?
Yes, comment on that. The short answer is the committee may be aware that we actually have a CHINS judge that is specially assigned as statewide. That's Judge Howard Kalpis. When I saw Section 14, the email went out to Judge Kalpis and said, are you willing to work with me and consult with DCF and other stakeholders if the legislature would find it helpful to try to address this? And the short answer is yes. And so we would certainly, as I understand that section has DCF putting together a report, consulting with the judiciary, and I can tell you that myself, Judge Kalpis, and any other judges or those who may be of assistance would be standing by to work with DCF to try to structure the policy that you're putting forth or what would work to effectuate that policy in statute.
Thank you, Judge.
And that
Another question, Judge Representative McGuire.
Yeah, good to see you, Judge Zornay. Just quickly, and I did speak to Representative Donahue on this, and I think we will get it clarified. But one of the concerns I was having, and I'm all for this, but you actually kind of touched on it, is the youthful offender status. My concern is that those are supervised in different capacities and so forth. And my concern is that this bill could unilaterally go across the board for those that have youthful offender status and to get some type of interpretation into this bill that allows clarity for that, because judicial review on a aftercare is much different for a youthful offender than somebody that's under the child welfare system of DCF. So I guess what I'm getting to is, does the family division obviously considers youthful offenders legally distinct from other DCF custody youth? Is that correct?
It's a different category. And if your intention is to say that we do not want this bill, in other words, the homeless youth bill, if we don't want this section to apply, you could put language in that says that these statutes do not apply to any individual under
Youthful offender status.
You should make it very clear to exclude that group if that's something that works. Now, DCF, I'm sure, should have a much better knowledge as to funding streams. Can you exclude a group? Things like that. I don't have any knowledge about that, but to the extent that there's a category that you would not want to see captured within this bill, you can exclude it. And again, subject to whether that works for all the other provisions of the bill and funding that you might be trying to obtain.
Yeah, and the reason I bring that on up too is because the bill at this time clearly states children in the Department for Child and Family Custody, which would pertain to all of those categories, whether you were a full offender. And my feeling is we just need to get that clarified in regards to the recognition of, youthful offender status is much different than what's being applied here.
I'm sure DCF has some positions they can advise on that.
Thank you.
So,
I think we're back to you, Judge Zone, if you have any additional comments.
I do not. Thank you very much.
Okay, are there any further questions or comments from committee members? Thank you so much for your patience with our scheduling issues today, Judge. All righty.
I had the screen up. I saw you on the floor. You were busy. Have a wonderful day. And have a great.
We were doing a lot of listening today. That was good. So,
have a great town meeting. Enjoy town meeting week. Take care.
Thank you. Thank you so much. Thank you. It looks like we have a crew here from Department for Children and Families. And thank you so much for everybody being here today and for adjusting the schedule. So, Deputy Commissioner, are you going to start us off? It looks like people are just sort of getting into the chat room here, maybe into the Zoom room.
Yes, I am. We do have a large crowd today. Thank you so much for inviting us to talk on this proposed bill. I want to start off, one for the record. My name is Erica Radke, and I'm Deputy Commissioner of the Family Services Division. And I want to...
Deputy Commissioner, are we able to see your face by any chance, or are you having...
Oh, I'm sorry. Yes.
There we go. Thank you.
There I am. I thought I pressed that button.
Well, sometimes people have, Wi-Fi issues and not always able to see their face, but I thought I would check before assuming that.
Thank you. I appreciate that. With me today is got a lot of folks. We have Amanda Churchill-Kipp, Lindy Boudreau, Tyler Allen, Brenda Gooley, also Lindsay Barron, and I believe in the room we also have Hannah Markle. I don't believe I'm missing anybody. Oh, yes. And also we do have from the business office, Megan. Megan has agreed to attend as well. So with that, I do want to go ahead and just get started with our PowerPoint because I know that time is short. So let's see if I can do this here.
Well, we are giving you the time that you need this morning. We're going to work through our lunch hour so that, so just wanted you to know that in advance. Yeah, who is running the slideshow so that Lori can give them access?
Oh, that'll be me. I'll be running
Okay.
it. So do I just hit this,
I was gonna say, do we have that on our?
Here's the.
It's a slideshow that I have.
All right, hold on just a second.
okay.
Testimony, but, that's not a slideshow. Okay, so,
Yes, we met those, and Erica will, Deputy Commissioner will just present the slideshow. We can absolutely.
we would like to see the slide. Some people can't see the screen well, so,
Yeah.
can you forward that to us right now?
Oh, sure.
Somebody?
I can
Lori.
see that on Deputy Commissioner.
Okay, thank you. It's sometimes, there's issues with glare and, people's ability to, easily see the screen. So, thank you. So members, it will be loaded up on your, iPads, shortly. So, you can go ahead though, Deputy Commissioner.
Okay, great. I'll make sure. Now, if I just share this, is that all I needed to do?
And you're asking the
Should
wrong
be.
person, but I think so.
Share screen and then choose the.
Yeah, if you
Yeah,
share the
wanna share.
screen, yeah.
Looks like it's, oh, no, that's not it.
As soon as I get it too, I can.
Do you guys have it up on your individual screens? Because
Not
that
yet.
would work too. Okay. Because I can't, it looks like I'm able to share in Teams, but I'm not quite sure how to share it on Zoom.
And Hannah, if you want to join the meeting. and-
Yeah, I was just gonna-
Happy to. If
Yeah.
you want, you have the link, just want to join us.
So, Erica, Hannah's gonna join the meeting and she can run the slideshow for you. From this
Thank
side.
you. Thank you, Hannah.
Okay, so let's just wait a couple of seconds, while the technology is catching up with the people. Hmm. Okay, it is on the screen now, Deputy Commissioner.
Okay, let's get going then. Great. So again, thank you so much for having us here to talk about H 657. This is really an important opportunity to us because we really want the opportunity to share with you all our insights as a division regarding the proposed bill. And what I plan to do is just to first talk a little bit about our mission statement, because I think that'll ground everyone in our shared values before we move directly into talking about H 657. And the mission of the Family Services Division is to really, we engage deeply with foster and kin caregivers and partner agencies, as well as the community, to really increase the safety and law abidance of Vermont's children and youth, particularly those that we know are the most vulnerable that are in DCF care and custody. And when we're looking at H 657, we know that it's an omnibus bill, and it touches on just so many aspects of the work we do in DCF. And we know that that's because we all have a shared responsibility in the youth and children and families that we serve. So, what our plan is to walk through each section of the bill carefully and deliberately, and to give you an idea of where we are aligned, where we do need clarification, and where there may be additional discussions that can be had so that we can have more collaboration. And we really do appreciate the committee's work on this because we know that this was really a heavy lift to pull together this omnibus bill. So
I just want to say thank you to you and your staff as well, Deputy Commissioner, for the discussions that we had prior to the session. And some of these things are things that we know that we both are wanting to work on, and so appreciate that collaboration as well.
thank you very much. So I know I want to go ahead and get right into the section I'm going to be talking about, which is Social Security benefits for youth and foster care. And I've talked to Representative Noyes and a lot of other community partners about this because this is an issue we've been thinking about. And philosophically, we really are aligned in that we believe these benefits are intended to support individual youth, and we do share the goal of ensuring that they have these benefits uh, meaningfully and to help them in the most meaningful, helpful ways that they can, and for the youth that these benefits are designated for. Currently, there are two types of Social Security benefits that FSD handles on behalf of a child or youth in custody, and that's survivor benefits, or sometimes called residual benefits, and those are tied to a parent's work history. And then there's also disability benefits that's turned it's really tied to a child's disability or qualifying condition. And in the department, we track these funds very carefully, month by month, child by child, to ensure that these benefits are associated with the one youth that they are supposed to be used for. So when a youth exits custody, if the cost of care was less than the benefits received, then any remaining benefits are returned to the caregiver or directly to the child, depending upon their age. And that's not a typical circumstance. Generally, the care of a child in custody exceeds the amount of benefits that they receive. So, and when that's the case, then the state does cover that difference. And at this juncture, we do believe, looking at the proposed bill, we need some additional time to fully assess how the proposal could be implemented in a way that avoids disruption to youth and maintains system stability. Recent discussions with federal partners suggest that there may actually be an iterative approach that we are planning to explore with them to see how that would look in practice, because we understand the feds are also supportive of having these benefits used specifically for the youth in custody, given to the youth for their use. In thinking about how that could work, we've been thinking that there's a potential step in that direction that could be considered as sort of a phased in or partial distribution of benefits. For example, allocating a percentage of monthly benefits directly to a youth. And this is something that we could do while implementing pathways or administrative requirements or federal considerations that need to be further clarified in order to make sure that this is all done in a way that maintains the system for uh, all of the youth in custody and the children that are receiving these benefits. It's really, for us, an incremental approach really will allow us to move forward with this bill's intent while ensuring that any changes are done, that are implemented in a thoughtful and responsible way. And this is something we really are committed to continuing to collaborate with you as the committee, as well as the federal partners that we've been speaking with.
Thank you, Deputy Commissioner. We have a question here from Representative Noyes.
Yeah, thank you so much. Appreciate our conversations and working with the department on this. So you said you needed kind of a period of time, and I was just wondering if you know how long that is.
I don't have a specific timeline. That's absolutely a reasonable question. This whole thing of an iterative approach with the feds, I was just made aware of it a couple of weeks ago. And it's hard to get a hold of them to even have a discussion. But the commitment is to discuss with them what their recommendations are, because the way it was framed was that they are speaking with other states on how to do this. So it's something we're committed to doing. I can't tell you exactly when and how long it's going to take.
And just a follow-up question, you said that currently you're using these benefits to pay for the individual's care. Is that correct?
That's absolutely correct.
So who pays for their care if they don't have survivor or disability benefits?
The state does.
Okay.
Deputy Commissioner, I think that this probably, I just want to, I guess, make sure that I'm understanding correctly. When you say FSD tracks the funds on a month-by-month and child-by-child basis. So I am making an assumption then that DCF or FSD is the representative payee for those children if you're receiving those benefits directly?
Yes.
Okay. And so, I'm sorry, go ahead.
Oh, I'm sorry, just briefly. And that is one of the things that I remember when we were speaking with Representative Noyes, is something that we would have to work out if we're no longer the rep payee, to ensure, who will be that person. And we want to make sure, would there be any liability on our part if the wrong person is selected? A lot of things that need to be considered when we're making that transfer over, because we do want to make sure, if we aren't the payee, that we have the right payee so that the child actually does get those benefits.
Sure. And, I'm not sure that the bill intends that there be a different representative payee, to be honest.
Mm-hmm.
You have systems that are set up for that already. And so, we haven't had that full discussion in committee yet, but just, from my perspective, I'm not sure that we would be expecting DCF to relinquish being representative payee for those children with benefits. So I don't know if that helps to clarify that for you or not.
That is helpful. And I know that, I guess there's a lot of different ways we can look to do it, because I do believe New Mexico, I'm not sure if it's New Mexico. I know some of the states do decide that they're not going to be the payee, to really sort of step out of the business, particularly when it's a child aging out, for that freedom for them to administer those funds. But it's all up for, like we were saying, we need more time to work out what we feel will be best for the kids.
Yeah,
I think
a workable solution. Yeah.
And the important thing, I think, is that we are at least all aligned that in some shape, form, or fashion, that we do want the youth to have these benefits.
Thank you. I appreciate that. I think that the devil's always in the details on something like this, for sure. And we recognize that there are details to work out and issues to resolve. And I think that what we have is a shared commitment to have the youth be able to have access to these funds as they age out. And I think a transition process is a perfectly reasonable thing to expect, to see in a bill like this. And I guess I'm asking also if you have any specific language that you would like to see that reflects that, because that it does make it, I guess, an easier process if your legislative counsel can be in contact with our legislative counsel. And if you have any proposed language, because it just makes it easier than us trying to guess what it is that you're looking for. I'm just trying to be honest about that.
No, I appreciate that. We don't have proposed language at this point because we really do want to get with the feds to figure out what they are envisioning for us. But I know, at least in looking at the proposed legislation, some things that stuck out to me was that there was a fair amount of, we've been doing some accounting, but there'll be additional reporting. There'll be some setting up of ABLE accounts or other accounts. There's a fair amount of additional administrative work that I don't believe we have FTE capacity for. So that would be something we would be looking for, definitely.
And I think that those are also things to get worked out between the treasurer's office, and they have a contractor for ABLE accounts already, so trying to work out also, like who would be doing what, which I think is a fair question.
Yes, no, and I was listening to his testimony yesterday, and I did hear they had contractors, and I know that he also felt that there were a few areas where he would be looking to DCF to administer. So that's just one thing I know stuck out in my mind. Other than that, I would have to wait for our council to really get with the feds, and of course with our leadership to talk about other things that we feel would be needed in the bill.
So, I think that this sort of applies to anybody else who, is going to testify on this, that we are looking to meet our deadline of crossover, which is 2 weeks from today. And so it would be, and I know you can't govern when you're going to be able to get the feds to give you a call back or, be able to be in communication with them. But I think that we can still craft language that would meet your needs and meet our needs and meet the needs of the youth, and the treasurer's office. I won't forget them, in a way that, I guess, formalizes what the intent of our process is moving forward, and maybe can develop a timeline to get these various kinds of questions and issues resolved. So I'm hopeful that we can get to that point. And like I said, it would be helpful if we can engage your legal counsel. With Katie's on vacation this week, or this coming week, but she certainly would be available the following week to have any conversations that would be helpful to ensuring that we are having similar goals here.
Sure, I can absolutely reach out to our council. I love that you worded it in terms of understanding moving forward, because I don't know at this point whether we can do more than sort of outline what our goals are. We are really still at the initial stages.
Yeah, I think that the purpose of having this section in the bill is to lay out that our expectation is to move in this direction, and that we know it will take a process to make that happen, and probably some additional legislation at a future point. But just to be clear that we, the inclusion in the bill is so that we can, I think be clear about the message that we're sending on this policy, on what the future policy direction will be.
That makes a lot of sense. And again, it was our Revenue Enhancement Director, Heather McLean, and I have been talking with Rep. Noyes, and we've found it to be really helpful to do that work up front to sort of so we could all understand what our positions were and to share information.
Okay, and we will continue to do that over the next couple of weeks.
And
Okay.
yeah, and
Yeah.
I
go
have
ahead.
some language from Arizona that
Okay,
I'll send over on that.
okay, great.
Okay.
Okay, I think we got a lot of topics to cover, so we should probably move to the next topic.
Yeah. Let's go on to the next slide then, and I believe Lindy Boudreau is ready to introduce herself and get started.
And members, we do have this on our website now, if you want to see it up close.
Thank you, Erica. For the record, I'm Lindy Boudreau. I'm the Adolescent Services Director at Family Services. So we are in support of providing meaningful support and resources to unaccompanied homeless youth, and we believe that that support should align with our current statutory authority. We also agree with testimony that was provided earlier this week by the OCYFA and Marshall Paul that having DCF Family Services specifically hold the certification and support might not be best suited and should be reconsidered. We feel that having an agency that holds responsibility and resources for housing might be better suited to be able to provide the support to these youth. That will eliminate confusion about our role, given we would not be providing any supervision or support around concerns of child abuse or neglect or justice involvement. And it will also avoid any unintentional supervision by the department. Hannah is going to speak about concerns about human trafficking.
Lindy, before we move off from that, I understand what you're saying. I think it makes some sense there. And wondering, I'll wait. The question is not really like formulating. I have the concept in my brain, but it's not really formulating it as a question yet. So let me just check in with my other members here if you have a question on what Lindy was just referring to. We did hear that yesterday, so appreciate that people seem to be on the same page about that. So okay. Let's move to the human trafficking. Thank you.
Thanks, Madam Chair. For the record, the Director of Communications and Legislative Affairs for DCF Family Services. I'm happy to sit in the chair.
Yeah.
If that's helpful for folks. I didn't want you all to crane your necks. And we have submitted 2 memos within the last couple of days with a bit more detail surrounding the points that Lindy just made on unaccompanied homeless youth. So that could be helpful for the committee to consider as well. And briefly on human trafficking, these cases and this population experiencing homelessness and kind of transitioning into their adulthood are at statistically an increased risk of both labor and human trafficking. I did cite a study in that memo. It is about 10 years old, but it did come from our trafficking expert at DCF and is relied upon by experts in the judicial system at times. And we would have been remiss if we didn't just mention this to the committee as something to consider. The increased vulnerability is something that as Vermont's Child Protection Agency, we do worry about for young people. And we are proposing that something be added in the language specifically around some safeguards, whether that be a screening tool that's populated and sent to the agencies that can be certifying youth in this capacity, or in some sort of other manner, but we would have been remiss if we didn't touch on that topic as well. And I am not the expert in the interstate compacts on juveniles. That would be Tracy Casanova, whose scheduling wasn't quite matching up today, but we did also just want to mention that we wouldn't want this to be any sort of method to kind of circumvent that legal process. And we do have some more kind of concrete explanations surrounding some things that could be put in place for human trafficking supports, and would really want to be leaning on experts and not kind of pushing that onto the people that are potentially certifying these youths, as human trafficking is quite nuanced, as I know you all know. And we would just want to be making sure that that is an expert opinion, supporting that youth to ensure that they are not being victimized. Essentially.
And I think Representative McGill has a question, and if Tristy's able to address the, if she has particular things that she, because I know there's a balance between we don't want to have conflict. We don't want to have anything conflicting in this bill with other statutory language or, federal stuff around human trafficking. So we certainly can have her in when we get back if she's available. Go ahead, Representative.
I was just gonna say, I was really glad you all raised this point, because this was exactly why I brought this bill. As we know, there are youth, independent youth, I really like Marshall's term for it, who are out there and they are being trafficked and not having access to ways to get food, to somewhere safe to sleep, makes them even more at risk for trafficking. I would actually like to connect with you all, because all of these organizations doing this work with the youth who can gain consent operate under these. They're required by their federal funding to do trafficking screenings, to follow the compact and ensure youth are connected back to their state if they've come here from somewhere else. So there is some federal language we kind of operate under. So it might just be something great to connect about. And then, but your testimony made me think, it's like, we really don't talk about trafficking a lot in Vermont, but we also know it's increasing. And I'm just wondering if this is an opportunity for us to start really recording that and collecting. It's really hard data to collect, but, and there's places you can find little bits of data. They're not in one place. And I think really it's our responsibility as a state to be tracking this information, and the legislature should be paying attention and making sure we're addressing these increased threats. So I don't know, something that just kind of sparked me, but I really appreciate you all raising this issue, because it is really important.
Yeah, and it's really to put you in touch with Tracy Casanova as well. I do not want to speak as the expert in that subject by any means. But did consult with her on the points that we're making today, as well as the information that's included in the memo. I'm happy to connect you.
And I think she and I met in the cafeteria like last year or something, but so yes, I would appreciate that.
Okay.
Thank you.
Thank you. I think we're moving on to restraints in the transportation.
And I believe we were going to skip past those slides, because when we spoke with Rep. Donahue, I know there's going to be some work done.
Yes.
So we can move past those, even though Tyler Allen is present online. But we can skip those slides and move on to the next area, if that helps.
Okay. I don't want Tyler to miss an opportunity to say something if he has any particular insights or things that, we should be aware of that we might not be.
Yeah, I'm certainly here and available. For the record, my name is Tyler Allen. I'm the High-End System of Care Director for the Family Services Division. I have comments on each of these slides. My impression was that we wanted to take some of those comments offline and revisit them later, but I could generalize for maybe for the purposes of this discussion. You all have the slide deck so you can see what's in there.
Mm-hmm.
One thing I wanted to make sure that the committee was aware of is the responsibility of Family Services Division to be not only responsive to the individual needs of the youth in our care, but also to the communities with which they live. So there is that public safety component of what we do. Mechanical restraints in transportation. I think the high level talking point here is we would be happy to provide a regular report, which I think is what is required in this. But the one area of future maybe discussion is that we don't directly oversee law enforcement, and that includes sheriffs. We oversee a contract, but what a sheriff does to make, or law enforcement does to make a determination around what is appropriate safety needs is left to the purview of those law enforcement officers, is kind of the high level. And I'm sure that generates a lot of thought and questions for folks, but I do think it might be helpful in a future time or now to describe the process by which we engage those law enforcement when that is needed. I did hear Attorney Paul's testimony yesterday, which I found to be quite compelling, an egregious situation. I think that steps outside of how we contract with sheriff's departments. I think perhaps the state police response is different than what we do with sheriff response, but what we do engage with the sheriff to do secure transports, but it is very rare that we actually utilize a mechanical restraint compared to how often that's deemed not necessary. And so we have a form that we fill out, we present the risks to the sheriff at the point of, and for example, last year we had in 500 plus examples, there were only 23 examples of which it was deemed necessary to use some form of mechanical restraint. So I just want to make sure that things are in kind of context.
Yeah.
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 So I think that's the high level point I'd make on mechanical restraints, and I can pause with that. If that generates questions.
Thank you. Thank you. And yes, I'm aware there's further conversations happening with Representative Donahue on this. And I'm thinking also, committee, it might be good to have Tim Lueders-Dumont in from the sheriff's Department of Sheriffs and State's Attorneys to review the procedure from their end of things. Okay. Thank you very much, Tyler. Appreciate that.
And then I had 2 other slides. I realized I was off slide, but the slide that's on is the solitary confinement slide. My understanding is a lot of that has to do with the Department of Corrections. That's probably a more relevant term to the Department of Corrections. We don't have solitary confinement as a practice in DCF.
Yeah.
But I just did want to take this moment while I have the stage to show appreciation. I think there is the way that this bill looks at solitary confinement is more akin to the practice of seclusion, which is an intervention that is grounded in the immediate safety of a youth and the people surrounding them. And I think that's a really healthy way to be looking at any time we have a young person in an isolated environment, that we are doing so with extra attention, and that it is really grounded in the idea that we are providing for the safety of them and other people in that moment, and that we're constantly monitoring and being attentive to that need. And I think this bill does have some of that. And so since I saw those in this section, I think it is relevant to the section on restraint and seclusion, which is another slide. Perhaps it's the next slide, Hannah. And I noticed the bill speaks more about restraint specifically than seclusion. Seclusion is, as I said before, a practice that's grounded in safety in the moment. And in my mind, there are different circumstances call for different response. And I think if I could have a seclusion environment, I would always prefer that to some form of restraint. And in some cases, I would prefer to see a mechanical restraint employed if the alternative is a physical restraint, because I think all these decisions should be made at minimizing the trauma to those persons receiving that particular intervention at the time. And of course, they're always grounded in safety first. And then I think we should build in a lot of safeguards around these practices. I think there already are safeguards in these practices, and I'm always open ears to more safeguards around the practices. There's, I think, a couple slides on seclusion restraint, and I just want to kind of make clear our advice is to not have a universal ban on some of the practices. We see chemical restraint, prone restraints, for example. I'm trying to remember. There's strip searching practices. When we're suggesting that we should not have a universal ban on such practices, it's not about our advising that this is the way we should do business. For example, because the slide is up there, strip searching practices is on there, that this is something that should be minimized in all circumstances as much as possible. And we have come a long way. For example, the Red Clover Treatment Program has been open for a year and a half now. They have never conducted a strip search on any resident in their care because it wasn't deemed necessary at any point. I do think there is the potentiality of a certain situation. If there was, an example, if a young person had historically had an overdose with a drug, an illicit drug in their past, and that was part of their presentation in the program, and they were to abscond from the program, and this is by way of example, for a period of time and come back, there might be circumstances where such a procedure is warranted. I think there has to be a lot of oversight in terms of how anything like that would be deemed necessary. And as I say, it's not a practice that I've seen in years now, but I think a universal ban provides some risk. Chemical restraints, by the same example, we don't authorize chemical restraints. That's not something that DCF can do or does do. Any treatment environment that can utilize a chemical restraint, the authorization of that is on the license of the medical professional that is determining that is necessary for this moment in time. So to some degree, this bill is saying that we should not be authorizing those things. Where it brings up a question for me is, does the nature of our having a contract with a provider that has the capacity to do so under the direction and licensure of their medical professional, does that constitute some level of authorization? And so that's a question that comes up for me. And I certainly wouldn't want to diminish our capacity to put a young person in a level of care that is needed because it is going to run us afoul of statute in this regard.
Sure.
So it's just an example I'm bringing up.
Yeah, no, I appreciate that. Just for being absolutely transparent, the answer is yes, in terms of if the department, any department in state government is under contract or has a grant agreement with an entity that's providing services, yes, you are responsible for what they're doing.
Agreed that there's some responsibility, and my worry would be that if that were to come into effect, then we would not be able to, for example, have any youth in DCF's custody go to a psychiatric facility like the Brattleboro Retreat or a facility out of state that might meet their need for risk that we would be in violation of the law putting them that in the environment. I worry about what that impact could be.
I understand your concern. However, I need to point out that it's not the use of medication for treatment purposes. It's the use of medication for restraint purposes, to limit the ability of the individual to interact with their environment and the people around it. And it's specifically for the purposes of that. So I don't want it to be construed that we have any intent of limiting the use of appropriate medication for individuals in their treatment. That is not what this is about at all. And I'm sure that you probably know that, but I just felt I needed to say that
It's
because
for emergency restraint.
Exactly, yeah.
I do know that, and I do trust the intention of the committee, Madam Chair, on that. What I'm trying to point out is could be a potential ramification of that, because there are care providers that do provide that as a portion of the services they do, and so this may have that ramification on who can be referred.
Gotcha.
And then lastly, prone restraints. There is that's the other form that is kind of universally bound, and I think I will, or banned, and I will yield that there is plenty of statistical evidence that shows that prone restraint comes with heightened risk of asphyxiation, death by asphyxiation specifically, and that is an area of concern. I do think there are two schools of thoughts around restraints, and one of the schools of thoughts is that a supine restraint is one that, depending on the individual situation, could put a young person at a greater degree of risk. And of course, staff as well involved in the incident. And so what we currently do is we work with providers who have a form of who have to be working with a nationally recognized practice model, and it's a modality that is considerate of safety. And so the advice on some of those modalities is that a prone restraint can be safer, that it requires repositioning upon the restraint going into effect. Essentially, putting somebody down onto their back or lowering somebody to the ground onto their back, it can be a traumatizing experience for a person, and it puts their head at risk of hitting a hard surface on the way down. And it is especially salient when the resident being lowered is of a larger body size, and is more difficult to lower to the ground. It could present more risk to them than the alternative. So I'm not saying this is a full-throated support of what we should be advocating for prone restraint over supine restraint. And we should always be advocating, and I think this bill does a great job of really pointing out that we should be always using de-escalation as a priority, and all modalities should be grounded in de-escalation primarily and secondary, and it is only physical intervention is only a last resort sort of scenario. But in some cases, it may actually be safer, of the opinion of these modality providers. It might be safer to not put that limit on prone restraints. I'll say this just as a factual, the implementation deadline of July 1st of this year would mean if we did put that ban in place, I think it would be very, very difficult to revise. We have several dozen contracts with providers that would all be needed to be revised. They would all need to find separate and different modalities to train their staff with, and they would need to train their staff up in doing so. And I think there are some there are huge logistical challenges to being able to do that by the deadline. So I just wanted to make sure the committee was aware of that.
Thank you. That's very helpful, specific feedback on the deadline issue. Thank you very much for your thoughts today, Tyler, and keep them coming, okay?
You got it. You're welcome. Thank you so much.
All righty.
Looks like next up is judicial review of aftercare placements. And I believe, is that Brenda or is that Amanda?
I think we can team it, and good afternoon, everyone. I am Brenda Gooley. I'm the Director of Operations for the Family Services Division. And I'm happy to start out speaking to a point of clarification that I think we need to make, which is the language aftercare could be in reference to two different aspects of our work. So I believe Amanda Churchill Kipp is going to speak to the part of our work that is in reference to our youth development work and transition age youth and those services. And then I'm available to speak to provide clarity and speak to any questions there may be regarding the aspects of aftercare that have to do with the Federal Family First Prevention Services Act.
Okay, thank you.
So I think just building off of the slide that we have up before you right now, with regard to the FFPSA, I think what we wanted to be able to point out is just, so prior to passage of the federal FFPSA, we had, well, if I go back a decade, we had over 200 youth in DCF custody that were placed in residential level care, where we were pulling down federal Title IV funding for those placements. And then when the FFPSA passed, we were no longer able to draw down 4A funding ongoing. Today, we're able to draw down 4A for the first 2 weeks of some of those placements. And what the FFPSA did was it put into effect requirement that a series of things needed to be in place in order for states to be able to draw down those federal dollars to support residential treatment program placements. So they coined the phrase qualified residential treatment program. And in order to be qualified, there would need to be a judicial review, there would need to be aftercare, there would need to be accreditation, 24/7 nursing, trauma-informed care, right? So there's a whole laundry list of very significant services, supports, and oversight that would need to be in place in order for states to be able to draw down those funds. And then, of course, states need to be able to demonstrate that the youth is 4A eligible, that they are receiving 4A eligible services, and they're in a 4A eligible placement, all of which requires tracking that we are not able to do unless and until we have a comprehensive child welfare information system in place. So Vermont is not ready to move forward on any of that right now. So we just wanted to make sure we were clear that that aftercare, and if it is in reference to youth stepping down from residential level care, that language that the federal government uses specific to FFPSA for a drawdown is not currently able to be in effect. I'm not sure if you're hearing a question.
Yeah, I have a question. You make a note of an estimated $1.2 million unfunded mandate. And this question, it might not be connected. And so I'm asking a clarifying question. So I'm aware in the department's budget presentation for FY27 that you had a reduction of an amount that's roughly similar to this. Because you weren't able to do the things that you just talked about, essentially. Is that the same? Are you familiar with the budget reduction that I'm talking about?
Yes.
And are you talking about the same? Is this the same thing? I guess is my question.
I'm going to let Erica speak to that one, but I believe it's in reference to the judicial review aspect of this, of that part of the budget.
That's my understanding as well.
Hi, Megan Smeaton, Financial Director, DCF for the record. I'm going to jump in here. Yes, so we proposed eliminating the budget that we had for aftercare as part of our budget proposal for state fiscal year 27. And it is our understanding that that was accepted by House Human Services in your recommendations to House Appropriations. However, this bill sort of does the opposite and goes back to requiring it without providing the funding. So that would result.
I just wanted to make sure we were tied. Thank you for clarifying that, Megan. Yes, I understand what we did in our memo. I'm just, we're also aware that there is federal funding in order to be able to implement this. So I'm just, there's a difference in what we're able to do right now and the policy that we should be striving towards. That's the only difference the only distinction I'm trying to make. So, I mean, we understand some of the data limitations, and all of that stuff. I wanted to know if I was, if we were talking about the same thing, and it seems as though we're in the same ballpark at least.
Yes, I believe we are. I'll just add a little more information that might be helpful. So within the state of Vermont today, we have 89 youth placed in residential level care. So I do want to be clear that the trend line over the past decade is that the number of youth in residential level treatment has steadily decreased. That is part of the intention behind the FFPSA. And so, that safe reduction of utilization of congregate level care is work that has occurred that I think is beneficial of youth. And there is cost associated with implementing all of these things. And at the same time, we are not able to draw down any federal 4E funds to do that work unless and until we have all of these pieces in place.
Thank you for that clarification. Kind of a chicken and egg thing, isn't it?
Yes, indeed. So I think from here, it might make sense to turn it over to Amanda Churchill-Kipp, who can speak to, particularly with regard to our youth development work and aftercare for youth in DCF custody in general.
Great, thanks, Brenda. For the record, my name is Amanda Churchill-Kipp. I'm a policy and practice specialist with Family Services. We weren't clear from the draft whether you may be talking about extended care agreements, so we did prepare to share a little bit with you about that. We have been supporting youth to access extended care for over 19 years now, since HHS championed the Youth in Transition Law in 2007. We've supported hundreds of youth to access supportive housing agreements over the years. And we're currently supporting about 85 youth with extended care agreements through DCF and also through our youth development program, YDP, which is our contracted transition and aftercare program. These services are primarily state funded. We do receive a grant through the federal government, the John H. Chafee Foster Care Grant, but those funds primarily support the services, and then state funds support the actual housing agreements. We do have the opportunity to leverage federal 4E for the population of youth who are over 18 and opt to remain connected to services. It does come with some added layers of eligibility, administration, and tracking, particularly judicial oversight, which we've not historically had for youth over 18. And we have had conversations with the judiciary over time about this, and we are interested in exploring this further. We appreciate the prompt in section 14 to collaborate and plan together around this. And it would be really wonderful to grow our resources here and to hopefully serve some additional youth in some greater ways. I would also just agree with some others around comments to perhaps try to tackle and hone section 13 after we've accomplished section 14. And glad to answer any questions about the steps, what's happening now.
Thank you. I don't know if you happened to hear Judge Zone's comments just before you folks came on.
I did, yes.
I was just wondering if you had any thoughts about, he felt like, again, we should offer some clarity, so if we're like, if the judiciary doesn't approve a plan, what then, kind of thing. And, what are the options then at that point in time? So I don't know if you have any thoughts about that.
I do, and I think that would be important work to flesh out together. Judge Zone was exactly correct. It is pretty vague the way that the federal language reads around best interest determination and ensuring that the department continues to work with youth toward the development of accomplishment of a permanency plan, which often is independence. That has been like a key question. What is the role of the judiciary here, and what are the options really? So yeah, I think that we would want to address those questions together. Also interesting in terms of like the federal program instructions around extended care, the forum in which these judicial determinations are made is not prescribed. So it can be fairly flexible, youth oriented, doesn't need to be like a courtroom setting, for example. So there is a fair amount of latitude and opportunity to Vermontize this process.
Okay, all right. And it sounds like you are agreeable to working on that process with the judiciary.
Absolutely, yes.
Okay, great, thank you.
Thank you.
Thank you so much. I think we can move on to the next section.
Okay, next up then is the Pregnancy Working Group, and I believe Brenda is going to speak to that part of the proposed bill as well.
Yes, thank you. And I definitely appreciate the opportunity to talk about our work in this arena and the opportunity that the working group represents. I did want to start out by clarifying first and foremost, as Erica started out with in the beginning, that our mission is to ensure that children and youth remain in the home whenever it is safely possible for that to occur. And so this foundation is an important part of this conversation. And we have worked hard, I would say, particularly over the past decade, since the legislature commissioned UVM to do a study on our custody entrance rate, to look at how in Vermont we can ensure the safe reduction of custody entrance rate in the state. And so we know at the federal level, we are required to make efforts to ensure that children remain safely in the home. And there are circumstances where an individual could be pregnant and there could be concerns that that infant upon birth would be in harm's way. And so we do have within the state of Vermont, Vermont State Statute, Title 33, Chapter 51, where we have the ability to conduct an assessment. And we are doing so in circumstances where there is a level of concern. Now, that could be concern due to a level of substance use occurring in the household such that the child could be in harm's way upon birth. It could be circumstances like serious physical injury, where a child in that household has been seriously harmed, or even where a child maltreatment fatality has occurred, circumstances where there have been termination of parental rights proceedings, where we know that if we are able to have a level of involvement and support with that family, there's the opportunity to prevent the need for that child to come into DCF custody at birth, because we're able to work with the family, work with extended family, work with natural supports, work with treatment providers to put pieces in place that will ensure that that child is able to remain safely in that household upon birth. So, when I think about maybe one significant data point to share with the committee, if I look back to 2015, 2016, at the peak of the opioid epidemic, we had over 1,400 children and youth in DCF custody. As of February 2nd, 2026, we had 772 children and youth in DCF custody. So we have seen a steady decrease in the need for children to come into care for their safety. I think very much due to these types of efforts. So I want to just provide a quick note of clarification. The word surveillance is not language that anyone in the Family Services Division would ever use.
Yeah, we don't like it. We don't like it either, Brenda. So thank you. Thank you for the suggestion about the name change. I just want to, be clear with you. We didn't like it either, and we're looking for something different as well.
Thank you. Yes, we are about supporting families for children to be able to remain safely in their care. And so, being able to intervene in a family where there could be an infant coming into that household, we know that that is a vulnerable time, and families deserve support at that vulnerable moment. So we do have policy that speaks to interpretation of the statute that I've mentioned, that in which we would be opening for assessment in the last 30 days of a pregnancy so that we can offer that support, have conversation with the family about what could represent that child being in harm's way and what steps can be taken in order to make those changes proactively so that that infant can remain safely in that household. And so we do, ensure when those calls of concern come in that we are responding in that 30-day window. And so that, the language about the pregnancy tracking is no more than that. So I just think that's probably also a valuable point of clarification, that it's the last 30 days of circumstances in which there is a concern, very specifically a concern that child abuse or neglect could occur to that newborn infant. Those are the circumstances under which we would be involved, and not beyond that, right? So it's not a generic, pregnant women across Vermont. I just think it's an important area of clarification to make. Thanks.
Appreciate that, Brenda. I have I guess a clarifying question. So if there had been a concern raised or an allegation made about an individual, when does the individual become aware of the fact that that has happened and that you would, then undertake your, supportive services and interventions?
So it would be during those last 30 days that they would typically receive a reach out call to say, that I understand that you're expecting due soon. It sounds like there is a level of concern. You may have some vulnerabilities. You deserve support. I'm here to talk with you and see what we can do to support you and your newborn infant to be able to be in a safe, healthy situation, right? So that's the approach. It's an assessment. It's not an investigation, and it's not a court intervention. It's a call of concern, and then an assessment is conducted in order to provide those prevention level supports. And if it's a substance use related situation, there are models such as the CHARM team out of Chittenden County that have actually received national level recognition regarding the work that's done, the collaborative wraparound work that's done in order to support women and their infants who are engaged in treatment and engaged in wraparound services in having that child remain safely in their care. So there's, I would say, incredible collaborative work being done in the state of Vermont that we're very proud of.
This might be a good area for Hannah Marble, who recently was the district director, to step in and sort of walk through what an assessment actually looks like. I'm hoping the committee might find that helpful.
Yes, if we could do that, in a brief way, I think that would be good.
Review, Madam Chair. For the record, again, Hannah Marble, Director of Communications and Legislative Affairs for DCF Family Services. As Deputy Commissioner mentioned, I'm very recently out of the field. I've been in this role since late September, and testified to the committee years ago about some experience in the field as well. So just appreciate the opportunity to provide some education. So in a prior role was the district director in St. Johnsbury. Prior to that, a supervisor. Prior to that was a worker in the field for around 5 years, primarily working.
Thank you for sticking with DCF and state employment.
You're welcome. So for the 5 years that I was working in the field, I wouldn't want to put a number on it, but roughly I worked probably 35 to 40 of these cases. The long and short of it is an assessment. The initial call to the parent typically is occurring within 72 hours of that report being received when
It
it
might
is
not be
accepted.
in the last 30 days.
Correct. So
Okay, that's what I was trying to understand. It didn't, so I mean, if somebody, if there was an initial call, say in the first trimester of somebody's pregnancy,
Yep.
you would be making, the department would be making a call within 72 hours to that.
I see what you're asking.
Do you understand what I'm saying?
Do.
Okay.
So the initial call could come in the first trimester. That case will not be assessed until 30 days prior to that mother's or that pregnant person's due date. And so when that assessment is 30 days prior to the due date, so let's say they're due on December 30th, we are becoming involved on December 1st. Pardon my days here.
Yeah.
And on December 1st to December 3rd, we may be calling and saying, hi, this is Hannah from Family Services. We've heard about your pregnancy. We want to make sure that you're supported and have the services that you need. How can we help you? From there, I will say testimonially, more often than not, in my caseload experience, those babies were staying with their mothers within that time frame. Because that time frame allows us to get in and do very focused, concentrated work, connecting with services, connecting with WIC, pulling together family safety planning meetings with every family member that wants to support that mom and that baby and that family, and saying, maybe mom is struggling with substance abuse. Who can drive her to the MAP program to get some treatment? Who can provide, 24-hour support for mom and baby upon their discharge from the hospital? Who's keeping logs of when baby is eating? If mom is struggling and is potentially relapsing, which we know is a very common part of recovery, who is jumping in from this woman's network to say, I'm here, we're going to call DCF and say, we're struggling, but we have a plan. And also in that time frame, we are making referrals to the services that Brenda mentioned, as well as nursing support, BNA through visiting nurses, WIC, things of that nature.
So I'm not sure I really got my question answered. I appreciate all of that detail.
Of course.
So I just want to make sure that I think maybe you've answered it, but I want to make sure I am understanding it. So DCF gets a call in the first trimester. The individual, the pregnant woman, is not notified until 30 days before their due date that you received a call 6 months earlier.
Correct. In the 6-month period earlier that you're referring to, there is not intervention.
There's no intervention.
There's no intervention.
They don't even know that somebody's called to indicate a concern.
Potentially, we at times would hope that medical providers and folks that are supporting this mom have said, this is why I needed to make this call.
Yeah.
And I would just impress upon the committee that the majority of the calls that are made to DCF, there's no, unless the person is notifying the mom, dad, family that they have called DCF, it is not uncommon whatsoever for families not to know that a call has been made. And we want to ensure very clearly that mandated reporters are following what they need to do with their mandate. And again, from a field perspective, I have had the conversations over the years of, it sounds like maybe you and your team at the hospital can jump in and support this mom. Please do, right? And take that upon yourself. Hope that answers your question.
Yeah, no, it does. I struggle honestly on two different levels. Because one level being, if there is a significant issue and the mom doesn't have the kind of supports that she needs, and we wait an extended period of time, then we actually have endangered the child.
We're
by
doing a
waiting.
disservice. Yeah.
And then on the flip side of, on the other side of that coin is like, I think if I were in that situation, I would want to know that there had been a call. And so then not knowing until 30 days. So in any event, I'm appreciative of the fact that you're not opposed to a working group. Because I think we need to have some of these discussions about definitely understanding the role to, provide protection and support for the child and the mom in this case. And, you know, figuring out, you know, making sure that we're just, I guess, reaching agreement about how best to do that. So appreciate that very much.
And just lastly, in our memo, we did include some very specific thoughts for the committee about additional folks that
yeah.
can be involved just to support the integration of.
Thank you. Okay, that looks like we've come to the end. I really very much appreciate your you know, collaboration on this and the clarification of you know, the various items where we know that there's continued work to be done on this bill. And just Deputy Commissioner, if you had any final comments that you wanted to make.
Sure. I also, well, one, I see Rep. Steady has her hand up.
Oh, I'm sorry. Okay, I didn't see that. Sorry.
Can't see when the slides are up.
Yeah, you can take down the slides now, Hannah. That would be great. Representative Steady.
As a person that is pretty conservative, I've been told this bill is going to be at no cost to the taxpayer. Can all your organizations support this bill if it does get voted through? I just want to make sure, because I am one of those taxpayers. Can all your organizations support it if it does pass? I just want to be upfront with people.
Representative Steady, I think that well, one is just one organization. It's the Department for Children and Families. And they have identified at least one area that they think that there would be additional cost to. And they have identified through their testimony the places where they have agreement and collaboration, and we can work through the language. So hopefully that answers your question.
It does. Will we get a fiscal note, Teresa?
It all depends upon what the final language looks like, Representative Steady.
Okay, thank you, everybody.
Thank you, Deputy Commissioner. I couldn't see her hand on this end.
No worries. I just wanted to thank all of you for your work on this bill. I can tell, you know, omnibus and just so many areas and so many detailed questions. And we really are looking forward to continuing collaboration with you. And I'm glad that there were so many areas where we could have some agreement, and then those areas where we need further time, that you all are open to that.
Sure.
Thank you very much.
All right, thank you, and thank everyone who chimed in today. Appreciate it very much. Okay, committee, just give you an update on stuff that's happening. You were surprised probably that 545 was not up on the floor today. Representative Burt has decided to reoffer his amendment that we have already heard testimony on. But Lori, we should probably try to schedule him first thing on Tuesday morning. A week from Tuesday, not next Tuesday. That it's not a new amendment from what I understand. I understand it is the same amendment that he presented previously, and we'll take that up. I also wanted to check in with folks. So next, when we come back, as I mentioned earlier this week, is going to be a long week. Spit it out, Teresa. Would it be an undue hardship to ask people to come in on Tuesday before floor?
Wrong.
Okay, thank you. I appreciate that. Because that way we can deal with Representative Burt's amendment, and we also may be able to schedule a witness before that. And we've just added to our list of witnesses on this bill. So that will be that. On the pre-K, which is another thing that we're working on. So I think at this point in time that's going to be part of a bill that makes its way through here and then to Education and Ways and Means. we may have a little bit of extra time on that piece. As I said earlier, we will be starting earlier next, when we come back, and we will be coming back, most likely, to the committee room after floor. And I will just say that it's important, and that might not be for every day, but, it is, if you can watch your texting, for schedule changes that might happen quickly. Yeah, go ahead.
Are you anticipating like an 8:30 start?
I am anticipating an 8:30 start on
I just
Tuesday.
wasn't sure how early.
Yeah.
Yeah, okay.
8:30. Yeah. Okay, have a good week off, folks. Thank you for, coming in through your lunch hour. I appreciate it. And